everyone. Thank you for joining me for HR Dilemmas Answered. My name is Alaniz. I'm in our Thompson Co. Houston office, giving Kevin Mosier a bit of a break. So I'm going to be doing the presentation today. So what are we going to be talking about today? We're going to be discussing a wide range of topics, from free speech, social media use, to gun rights, to religious conflicts, service animals, cultural discrimination, and the Me Too movement. All right, let's see, having a little bit of technical difficulty with my moving of the presentation. But let's go ahead and get started and start talking about free speech in the workplace. So a lot of people don't understand that the First Amendment right is not this absolute, and it actually doesn't apply to the workplace. So a government can't prevent somebody from engaging in their First Amendment rights, but companies and individuals can. So we sometimes have claims where, you have employees posting on Facebook or in saying things that the company disapproves of. And I've actually had one case where an employee had posted on Facebook criticizing one of the company I was representing as one of their customers. It was actually a local governmental agency that they were criticizing. In that case, they had a dog a police dog that had died in the car. And she was very upset that the police officer had allowed the police dog to die in the car. And she was advocating that that police officer needed to immediately be terminated. Well, what happened is that, of course, the local government, the client, was not very pleased with that, and she was ultimately terminated. So she tries to sue her employer, the nonprofit, that's not a governmental agency, for infringing on her right to free speech. Well, in that case, to be able to sue for infringement of the First Amendment right, there's a section called 1983. But to have a 1983 violation, you actually have to have a governmental actor perform that action. And since the nonprofit was not a governmental actor, they could terminate for disrupting the relationship with the client. However, there are some limits that private companies are subject to. So employees have the right to talk about wages, hours, and working conditions. And employers that terminate employees for posting about that can get into trouble. So the National Labor Relations Act protects employees' right to discuss conditions of employment, safety, and so even if you're a non-union employer, you are still subject to the National Labor Relations Act, and you cannot infringe on an employee's right to discuss the conditions of their employment and their wages. So because of that, companies are dealing with employees that may be out on Facebook that are, criticizing the company, how they pay. So as an employer, if you can't stop them from doing that, what do? Well, one thing is that since employees have the right to talk about this, an employer should try to be transparent, come up with a compensation strategy or framework that they discuss with their employees. So the more it's open and discussed, you don't have to get into specifics of what each person is making, but you can talk about a framework and give them sort of the opportunity to come in and talk about any issues they may have. So the more the company tries to be transparent and open about it, and encourages employees that when they have an issue to come and talk to them, they'll have an avenue to complain instead of resorting to Facebook to complain about any issues. You're never going to be able to stop all of it, but you may be able to stop some of it and maybe cut down on some of it. And one of the issues that employers really come up against is having managers not recognizing that that is a protected right and try to discipline employees for talking about wages, working conditions, or even criticizing their managers. So employers need to make sure that their managers are aware of the right that employees have to talk about their wages and working conditions. So that's going to be a key for employers, is training. So you may, as a corporation, understand you need to allow them to do it, but if your front level managers don't understand that, then you can create a violation that you're having to deal with. And it's always a good idea to formalize that complaint resolution procedure for your company, so you can allow your employees to be heard and know that there is a mechanism for their complaints to be heard. All right, so we've talked about what employees have a right to complain about. What about hate speech? Is that something that's protected? So hate speech offends, insults a particular group, and no laws protect hate speech. And no laws protect hate speech from using that as a reason for terminating an employee. In particular, the National Labor Relations Board in the Detroit Medical Center case has held that speech can become so bad, and using racial slurs, et cetera, that it becomes laborious language, that when that speech is so bad using that type of language, then they lose the protection of the National Labor Relations Act. So there is a point in time where language can be so bad that it loses its protection. All right, so I'm having some help here to move us on to the slide where we're supposed to be at. So I'm going to give it a couple minutes. All right, so we've talked about the free speech. Let's talk about in the context of social media. So that's where most employers are going to have an issue with, is employees getting out there and posting on social media. So as an employer, what do? It's important to educate your employees about their social media policies and remind employees that there's the blurred line of personal and professional lines. I mean, you'll often have somebody with their own Facebook page, but on that page, they'll identify who they work for. And maybe they get on their Facebook page and they don't do the correct privacy settings, and everyone can see it, and they're criticizing a customer. So that's something that you may want to put in your policies, that, you know, only certain employees can speak on behalf of the institution, and, you know, disparaging customers is not something that's permitted. And also proprietary information. They need to understand that even on their personal time, they cannot be allowing proprietary information to be put on their Facebook post, and that's completely off limits. And then talk about privacy concerns and employee confidentiality. And then advise them that workplace conflicts should stay offline. Now, you know, there's always that kind of push-pull. So we advise that when you have these social media policies, have one for a person's personal social media channels that don't disparage customers, don't disclose proprietary or confidential information, and put those in the private one, and then have a separate one that could be a little more constraining as to corporate social media accounts, as to who can post on that, what can be said. So having those kind of policies will help with dealing with employees that do a lot of posting on social media that may make the company look bad. All right, now coming to one of the controversial topics, gun rights in the workplace. You know, these days it seems like we're always hearing about some shooting here and there. And as employers, how do we deal with that? I mean, firearms are deadly and can contribute to violence in the workplace. And at the same time, there's the constitutional right to bear arms, and allows some citizens to be able to possess firearms. And so on top of those kind of balancing acts, you have different states that take different views. So for example, California says that the Second Amendment doesn't protect an individual's right to possess a concealed firearm in public. But then you have other states that don't have an issue with persons in the public carrying concealed firearms. So there's a difference of opinion, and depending on the state, you're going to have different situations to deal with. So as an employer, you don't necessarily want to delve into or take a stance on this very controversial subject, but at the same time, we as employers have to recognize that guns could pose a danger to our employees. And here's a couple of stats that I wanted to share with you. So about 3 million Americans carry loaded handguns with them every day, primarily for protection. About 1 in 5 reported carrying concealed handgun without a permit, even in states where permit is required. And this next slide shows that 12 states allow unrestricted permitless concealed carry. So as you can see, the states are across the board, have various different laws and what is allowed and what's not allowed. So as an employer, depending on where your office is, it's important to understand your state's laws and what you can do to restrict or not restrict firearms. So I want to talk a little bit about some of the parking lot laws. I'm going to go to the next slide and then come back to that one. So in this slide, it shows states that have parking lot storage laws. They include Alabama, Arizona, and where I'm in, Texas. And what those laws do is it allows employees that when they go onto their employer's parking lot to be able to store their firearm in the trunk or in their car while they're at work. In Texas, for example, employers can prohibit concealed firearms from being allowed in the workplace as long as they post the correct signage. But there's an Attorney General opinion that says, well, that just talks about handguns. They are free to possess firearms, including shotguns, rifles, etc. And if they have that in their cars, they can be allowed to store it. Some states are a little more absolute and say employees are allowed to have firearms in their car, and there's nothing an employer can do to infringe on that. So what do you do as an employer? You want to keep your employees safe. But no state has created a right for an employee to possess a weapon in the workplace beyond the parking lot. So with that in mind, what do we do to try to prevent workplace violence? Well, the first place to start is to have a workplace violence policy that addresses weapons. And, obviously you need to look at your particular state law to see what's allowed and not allowed. But, to the extent you can, prohibit employees from bringing weapons in the workplace. Make sure your policy covers acts of violence, harassment, bullying, and other intimidation. And more importantly, make sure it's understandable and readable so they know what you're trying to prohibit or not prohibit. Set procedures for employees to report threats or violent acts. Set a disciplinary procedure for employees that violate that policy. And one thing that you may want to include is sometimes what happens is you have one particular employee that's concerned for their safety, but they don't have an outlet to express that concern. So if you can set up resources for employees, either a counseling service or some other type of mechanism that allows that employee to talk about their concerns about safety, because that's one of the important things about preventing violence is to recognize it and understand the warning signs. So the first avenue would be letting employees talk about that so you can see if there is a potential problem. And then workplace violence prevention training. That's also something that can help, because that type of training helps employees understand the warning signs, recognizing it, and then reporting it. You can't stop all violence, but if you know that it could be happening, you can take measures to possibly stop it. And you can't stop everything, but put emergency procedures in place. So if there is an unfortunate incident and there is some violence in the workplace, that you have procedures in place that your employees understand that if this happens, this is what we do. You know, whether it's calling the police or whatever the procedure is in place. I mean, some employers go as far as to have active shooter drills. So, you know, it's something that as an employer you may want to consider, because unfortunately, we can't stop everything, but if you have procedures in place, you can minimize some of the dangers. And one other thing, when we talked earlier about the parking lot laws, obviously you have to, in some states, you're going to have to allow an employee to store their firearm. However, you can avoid expanding those rights. So, if, as I talked about in Texas, where they can store their firearm in their car, but you can put signage in place that says that you can't have that firearm in the workplace. So really take a look at your state's laws and see how you can minimize allowing weapons in the workplace. And then consider security measures that control access to employer parking lots where the firearms can be stored. Having trained security personnel monitoring can help limit the likelihood of enraged employees trying to go and access his firearm and return to the workplace. All right, so that's guns in the workplace. So I want to switch topics and go to something completely different and talk to you a little bit about religious conflicts. So the United States is becoming a more and more diverse nation with, I mean, we've always been diverse, but the demographics are changing and continue to change. And with those change in demographics, you're going to have more diversity. And while diversity is good, more diversity can create, you know, potential conflicts when you have such a diverse culture. And so as an employer, how do we keep a harmonious, to the extent we can, workplace that recognizes people's religious beliefs without infringing on somebody else's religious beliefs? So I want to go through a couple of stats. So in a recent 2-year period, the number of religious discrimination claims filed with the EEOC has increased more than 105%. So, and then another stat is less than half of the workers said their employers had flexible work hours to permit religious observation or prayer. So what does that mean for employers? Well, it means that you're probably going to see more religious discrimination claims. And so as an employer, how do we deal with that and how do we prevent those claims? Well, recognize that as you know, our culture is becoming more diverse, different cultures are coming in. How do we deal with the different cultures and not allowing one to, you know, overtake the other? I mean, it all starts with a good harassment policy. As an employer, you're to be neutral and to have a policy that harassment and discrimination, regardless of your religion or other protected class, is just not permitted, and not allow one group to harass another. So to start with, have that in place. And have that training. And then what do you do with when you start getting request for accommodation to take off for, say, a religious observance. And the conflict that may cause that if you allow one employee to take off for a religious observance, how does that affect your other employees that may have to take off the slack? So in addressing that kind of issue, what you need to look at is what, as an employer, is your obligation to accommodate somebody's religious belief? Well, so the general concept is that if somebody requests an accommodation, an employer needs to engage in the interactive discussion and determine whether they can provide that accommodation. So for something like, I need time off because of a religious holiday, well, the employer needs to know, well, how long is that going to be? How long is that going to take? So you can determine as an employer, can I even accommodate that? And one thing an employer can do is that they don't have to allow every request that comes to them. If the request becomes where it's an undue burden and that it disrupts an employer's business operations, then they don't have to accommodate that particular request. So in the case of the time off, if that time off affects everyone on the shift and more employees are having to do more work than they would otherwise, that could potentially be an undue hardship for the employer, especially if they're going to have to hire somebody else to take up the slack. So in that case, it may be an undue hardship for that employer. But what if you have a bigger one, employer that has lots of employees and can just have somebody switch out and or somebody volunteer to take their shift, then as an employer you may have to allow that accommodation. What about religious dress and headwear? What do you do with that? So, you know, again, it comes back to, as an employer, evaluating whether you can accommodate that request. So, for example, if somebody's wearing a religious wear that maybe is flowing and you're working in, say, a machine shop and that dress could get caught up in machinery, then an employer may not be allowed to, may have to say, I can't allow that because it's a safety violation. Or what if there's some sort of headwear that the employee wants to wear, but by putting on that headwear, they can't use a respirator and they can't get a proper fit because of the headwear, then again, that might be a reason why the employer can't allow that. But unless an employer can show an undue hardship, safety, or a substantial business disruption, employers are going to have to allow religious dress and headwear. And here's always the interesting time is Christmas time and the holiday party. How do you not offend various groups? I've actually seen some companies that try to avoid the label of holiday or Christmas time to completely get away from any kind of religious connotation. And some people just call it end of the year party. You know, for an employer, parties are social events and should not be tied up into some sort of religious theme. So as a company, you know, at the end of the day, you're going to have to weigh, well, I probably shouldn't call it a Christmas party, but holiday is not that offensive and it shouldn't offend people. But when you're doing those type of parties, try to make sure that you take out some of that religious connotation so you won't get a potential claim. Now, I haven't had one of these, so I actually went and looked at some cases to see how employers are dealing with employees that attempt to proselytize in the workplace. How do you deal with that? There are some religions that advocate that as part of their religion, they need to try to convert as many people to their religion and talk about their beliefs. But what if they're talking about that to someone that is not receptive to that, or maybe is an atheist and doesn't believe in God? So how do you deal with balancing some employees' need to talk about their religion versus another employee's need to not want to discuss that and not want to hear about it. So I wanted to talk about some cases that have come out recently to kind of illustrate the difficulty in dealing with it and some of the things that you need to be looking out for when you are confronted with attempts of employees in the workplace to express their religious belief. So in one case, Downing versus West Haven Board of Education, a teacher sued the school district and a number of individual board members alleging the board had impermissibly infringed on her right to free speech and exercise of her religion when she wore a t-shirt that read Jesus 2000 J2K during instructional time. They told her she couldn't wear it and she needed to stop it and discipline her. She went and she sued them, saying, "You are infringing on my right to exercise my religion." In that case, the court agreed with the employer and said, yeah, you can do that. And their rationale was that the need to avoid disruption in the workplace outweighed the plaintiff's interest in expressing her religious beliefs. And so based on that, they sided with the employer. In another case, it was involving the State Commission on the Deaf and Hearing Impaired. They had a sign language interpreter who would interpret for clients who had mental health disabilities. So as part of her job, she was just supposed to interpret. She wasn't supposed to counsel, advise, or inject personal opinions during her interpretation. And so in one case, she was talking to a client during a break about his smoking, and she informed the client that the Lord had delivered her from smoking and asked if she could pray for him so he could quit smoking, and then started praying for the client in his presence. In another instance, that same interpreter had been interpreting for another client, and while she was engaged with the client about her religious beliefs, she told the client told her that she had been sexually abused, and the interpreter informed the client that God could help her with her problems, and she gave the client several religious texts. After several complaints from these clients, the employer reprimanded her and said, this is not your job, you're just supposed to be interpreting, you can't be discussing your religious beliefs with the clients. In that case, the court did side with the employer on the same basis of the last one, is that avoiding disruption in the workplace outweighs the plaintiff's interest in expressing their religious beliefs. And when you're limiting an employee's speech, and in particular when you're dealing with discussing religious speech, it's important to show that the reason you're doing it is because of a legitimate business interest. So like in that case that we just talked about, her job was to interpret, and when she was going kind of beyond the scope of her job and causing the clients to complain, well, the employer had a legitimate business interest to stop her from doing that and making the clients uncomfortable. And one of the other things that's important to note, that what they looked at is the court went to see whether the employer's policy prohibited certain types of speech and if that policy was neutrally applied. So they're going to look to, do you have a legitimate business reason? But they're also going to see that if you limit other types of speech and if you're enforcing that neutrally and not just picking one over the other. So those are just some instances of dealing with proselytizing. It's not something that's easy to deal with, and we're obviously always here to help dealing with this difficult situation. And so besides those cases, I wanted to talk a little bit about some recent matters that have come up. One of the big cases that has come out about religious discrimination is the Abercrombie and Fitch case. So in that particular case, Abercrombie and Fitch was hiring for new positions, and it was one of the sales clerks. One of the applicants came in wearing a hijab. The person interviewing her determined that she seemed qualified, but she had some concern about the hijab and went to her manager and said, well, she's wearing this hijab. It may violate the employer's policy about not wearing caps, and how they should handle that. And the manager said, don't hire her. So the applicant sued, and in that case, the Supreme Court came down and said that, one, they noted that at the time the employee hadn't even asked for an accommodation, and that so when the employer made the decision not to hire that applicant, it was because she was wearing a hijab, and for them that was sufficient to show religious discrimination. So that's one case where the employer just got it wrong and failed to hire because they were assuming things and didn't even try to make a religious accommodation, even though one hadn't even been asked for. Now, things turned a little bit differently in a different case involving the EEOC, where a company had refused to hire a woman because of her dreadlocks. The EEOC sued the company and said that the dreadlocks were an immutable characteristic of an African American. The court took a look at that and said, well, Title VII prohibits discrimination based on a protected class if you're dealing with an unchangeable characteristic. Hairstyle is mutable and can be changed, and it's not necessarily indicative of the African American race. And what they noted was that Caucasians could also have dreadlocks, and not hiring someone with dreadlocks can apply not just to African Americans, but could also apply to Caucasians. So in that scenario, the court dismissed the case because they didn't feel that dreadlocks were an immutable characteristic of an African American. All right, so all these religious conflicts and different views, as an employer, what do you do? How do you combat some of these issues that will surface when you're in the workplace? Well, first of all, having proper policies, employee awareness, and procedures around religious differences can lead to greater engagement in your workforce, increased productivity, and a reduction of potential lawsuits. And so one tool that can help with this is a diversity calendar. So what's a diversity calendar? A diversity calendar notes religious observances and explains how these observances affect the workplace. So that's a good tool that an employer can use to make managers and employees aware of different religious events and observances and how they're practiced, and gives them this awareness to help get to a place where you have an organization that's both friendly and tolerant of all groups. All right, so we've talked about religion, guns. So I want to change it a little bit and talk about cultural diversity. Cultural diversity, is that even a protected class? So what is that? We know that one of the protected classes is race and national origin, but cultural diversity, how is that protected? Well, cultural diversity can be a form, cultural discrimination can be a form of discrimination involving national origin discrimination or even religion or race. And so in looking at the EEOC guidelines on national origin discrimination, the EEOC has said that discrimination can occur because an individual has a physical, linguistic, or cultural characteristic of a particular national origin, and because of that are treated or discriminated against because of that characteristic. So, for example, if someone has an African accent and they're harassed because of that accent, that would be a form of discrimination based on national origin. Or let's say someone is wearing an African dress and they're harassed because of what they're wearing, that would also be a form of discrimination. So whether it be the way someone speaks or some sort of characteristic that's indicative of a particular group, that could be a form of discrimination. And you know, in some cases, you may have sort of a combination of a national origin to religion. So somebody wearing a hijab can indicate that maybe they're Arab or that maybe they're Muslim. So, you know, different things depending on what's there can affect different types of protected class. So what about rudeness as being part of someone's culture? Is that even something that happens? So I actually read an article where a French writer was fired because he was rude to a customer. And he sues because he claimed that I'm rude because that's just part of my culture, not just part of being French. I would say, looking at some of the other cases, particularly that one, the ESC case with the dreadlocks, is I think when you're looking at what is cultural discrimination, you need to be able to identify whether that cultural trait is associated with a particular group. Rudeness is not necessarily associated with somebody just being French. So that's something that's probably not going to be a valid lawsuit. So we'll kind of keep a lookout to see whatever happens with that case. All right, one of my favorite topics, service animals. So these days, I don't know if some of you have heard about how more and more people are getting emotional support animals and potentially bringing animals in the workplace. So as employers, how do we deal with that? Well, let's start with what the ADA states. So the ADA limits the definition of service animals to dogs. It excludes emotional support, comfort dogs, and therapy dogs. And you don't have to allow an animal if it is not needed because of a disability. However, watch out. Employers still have to consider whether an emotional support animal is something that they need to accommodate. So I want to talk about some of the recent issues I've had. So I've been dealing with a case where this individual has said that a cow is his emotional support animal, and you know, that trying to be excluded. Now, a cow is something that's a little more difficult to transport, to bring with you to different places. And so what do you do if somebody comes in and says, I have a cow that's my emotional support animal and I want to bring it to the workplace? Well, as an employer, you can require that employee to show that that service animal or emotional support animal can be trained to be in a work environment without disrupting the workplace or otherwise behaving inappropriately. So if you have this cow that can't be potty trained, that's so disruptive that it's affecting the business operations, then you could probably have them not allow it. But I've actually seen in some recent cases where miniature horses are being used as guide animals, and the theory is that the miniature horses live longer than dogs, so once they're trained, they live to be up to 30 years, so you can have them longer. And apparently they can also be potty trained. So if you get to a situation where someone has the service animal, look to, well, can you show that the service animal can be trained to work in an environment and not be disruptive? So that's going to be the key thing to remember when you're having to deal with a cow, a horse, or an iguana. So what happens if, on one hand, you have an employee that's come to you and say, you know, I need this emotional support animal. Can you accommodate that? And it's maybe something simple as a dog. But you have another employee that's definitely allergic to animals, and if you bring that animal into the workplace, they could have a severe allergic reaction. What do? Well, you try to balance that. So if it's possible to separate them to where you have on one side or even on a different floor, have that employee with that emotional support animal, and then you have the employee with the allergy to the animal on a different floor, that might be a way to accommodate it. But what if you're the small employer that you're in one area and you can't separate them? Then in that case, you may have to assert the undue hardship of not being able to accommodate it because you have another employee that would have an allergic reaction if that animal is allowed in. So those are different things that, as an employer, you may have to deal with when a service animal is being requested. All right, so what happens if you've gone through the analysis, you determine that, yes, as an employer, I can accommodate a service animal. So what do I do to prepare for that? One thing to consider is having a relief area. You don't have to do it, but to facilitate having a non-disruptive area, you may want to designate, here, go do it over here, so you don't have that conflict in the future. But what do you do about your employees when they start seeing an animal in the workplace? How do you deal with that? You know, first thing, talk to your employees, educate them, let them know that this is what's happening. Let them know here's how you interact with the animal, or in some cases not interact, and just disclosing to the employees that this animal is being allowed in the building, what they can and cannot do. Now, don't go into disclosing the disability or the accommodation, and so don't give them any more than they have to. All you have to let them know is that this is a service animal or a support animal, and that's being allowed, and here's how to interact with it. So that's some of the ways to kind of confront any potential issues that may come up if you do have to allow a service animal in your workplace. All right, so we've hit a ton of different topics, and so I kind of wanted to hit the last one. I know in the past we've had some harassment PowerPoints, but this is always a good one to be reminded of, especially in this day and age where more and more people are coming out and reporting. And so as an employer, it's important to address the Me Too before it becomes You Too. All right, as a quick refresher, we are finding out as more and more people are reporting that workplace sexual harassment happens to 1 out of 3 women between the ages of 18 to 34, and that they have been sexually harassed at the workplace. I mean, that's a pretty significant number. And in the past, a lot of women were afraid to report. But with the Me Too movement, more and more women are coming out and reporting harassment. So as an employer, you need to be aware that this could become an issue for your company and to get out in front of it. So quick refresher, there's different types of harassment. There's the quid pro quo, which is a demand for sexual favors in return for a work-related benefit. It usually happens between a supervisor and a subordinate. And the employee benefit can be positive or negative. So It could be, for example, I'll give you a promotion in exchange for a sexual favor. Or it could be the negative of, you don't do the sexual favor for me, I'm going to fire you. So that's the quid pro quo. And unfortunately, we're seeing that come out a lot more these days with the Harry Weinstein, et cetera. Then the other type is a hostile work environment. And that can involve not just a supervisor, but it could just be coworkers that are engaging in conduct that's offensive, from things like sexual jokes, you know, showing to other coworkers pornography, to touching another coworker. So it can encompass whole sorts of conduct that may rise to the level of harassment. And so what's important for employers is to educate their employees on what constitutes unwelcome offensive conduct, and to educate them on that offensive conduct can be not just related to women, but to anybody in a protected class. And what's offensive is what a reasonable person would find offensive. And if that conduct is happening so often and or so severe, that can rise to the level of affecting someone's ability to do their job, and can be something that's actionable, that employer can be sued over. So as an employer, what do you do with these? With reporting becoming more prevalent, it's going to be so important to make sure you have your policies out there that tell employees, here's how you report. And what you hear so often is that some people are like, I was afraid to report because the reporting mechanism was just to my supervisor, who may have been the person that's doing the harassment. Have multiple avenues to where they can go to HR, they can go to another manager, they can go to somebody that they can report. It's important to be able to give them an avenue so they can report it, so you know as an employer how to deal with it. Some employers have even gone to having hotlines and different mechanisms to where it can be reported anonymously, because so many, you hear so often that people are afraid to report. So the more you can give somebody, employees, the option to try these various things, because we as a company want to stop harassment and want you to report, and we're going to give you all these different avenues to do that. That's going to be important for stopping and dealing with if there is a harassment situation in your workplace. So I am nearing the end. I appreciate everyone staying around and listening to me on this. And if you guys, if there's any questions, because we covered a lot of topics and kind of touched just on some of them, like service animals is just a very complex issue to deal with, and religious accommodation is very complex. So if you guys have any questions or have a situation that you need help with, we're available to help address anything that comes up. So again, thank you everyone for your time, and that concludes this webinar.